We acknowledge the traditional owners of the country on which we are speaking today, the Gadigal people of the Eora Nation. We wish to recognise and respect their continuing connection to land, culture and community. We pay our respects to their elders, both past and present, and extend that respect to other Aboriginal people listening. This podcast represents a brief summary of the law relating to the issues raised and should not be relied on as a substitute for professional advice. Specific legal advice should always be sought in relation to any particular circumstances, and no liability will be accepted for any losses incurred as a result of reliance on this podcast by those relying solely on this podcast. Hello and welcome to Hicksons Health Hour, the podcast series that explores a variety of current legal health topics. Throughout each episode, you will hear from different members of our health team who have expertise in this area. We hope that you enjoy the podcasts and find these episodes valuable.
Hello, my name is Violet Stakova and I'm Special Counsel in the health team at Hicksons Lawyers. Today, I will be discussing the coronial process. You may ask, why coronials? It's simple, because in the words of Benjamin Franklin, in this world, nothing is certain except death and taxes. Aside from this, it is possible and quite likely that working in the healthcare arena, you may find yourself involved in a coronial investigation and ultimately may be called to give evidence at an inquest. The earliest recorded inquest in New South Wales was in 1796, which involved the investigation of the death of a convict. The current relevant legislation that governs the jurisdiction is the Coroner's Act of New South Wales 2009. Approximately 7,000 deaths in New South Wales are reported and investigated by the coroner each year. The Coroner's Court moved from the Rocks to Glebe in 1970, and more recently from Glebe to Lidcombe in February 2019, where it remains today. Her Honour Magistrate Therese O'Sullivan is currently the State Coroner. In addition, there are 5 Deputy State Coroners. All New South Wales magistrates are coroners pursuant to Section 16 of the Act. What precisely is the role of a coroner, you may ask? The role of a coroner is embodied in Sections 3 and 17 of the Act. Relevantly to the healthcare setting, the coroner's role is to 1. Investigate the manner and cause of death. 2. Consider if there are any deficiencies in the systems. 3. Consider if recommendations can be made to improve systems. It is not the role of the coroner to determine whether there has been negligence. However, it is important to be aware that the coroner can refer individual practitioners to their registering professional bodies for investigation. There are particular deaths that must be reported to the coroner. Section 6 and 35 of the Act deal with deaths that are reportable to a coroner. Section 6 specifically defines a reportable death. Section 35 requires that persons who have reasonable grounds to believe that a reportable death has taken place must make a report. A doctor may not issue a death certificate in respect of a reportable death pursuant to Section 38. In the event that a doctor issues a death certificate and that death falls within the scope of what is considered a reportable death, the certificate issued in respect of that reportable death is null and void. Reportable deaths are violent or unnatural, sudden deaths, the cause of which are unknown, deaths that occur in unusual or suspicious circumstances. The person died in circumstances where the person's death was not necessarily an expected outcome of a health-related procedure carried out in relation to that person, and the person died while in or temporarily absent from a declared mental health facility within the meaning of the Mental Health Act 2007, and while the person was a patient at the facility for the purposes of receiving care, treatment, or assistance under the Mental Health Act, or the Mental Health and Cognitive Impairment Forensic Provisions Act 2020. Relevantly to work in healthcare, it is important to understand what is a health-related procedure under the Coroner's Act. The definition of a health-related procedure is very wide. Section 6, subsection 3, states that a health-related procedure may be a medical, surgical, dental, or other health-related procedure. In circumstances where there is an unexpected death following a health-related procedure, the issue for consideration by the coroner will be the impact, if any, of that procedure, and specifically whether the procedure caused or contributed to causing the death. However, there are some medical procedures which are excluded from this definition. For example, the giving of an intravenous injection, the giving of an intramuscular injection, intravenous therapy, the insertion of a line or cannula, artificial ventilation, CPR, the insertion of a nasogastric tube, intra-arterial blood gas collection, venipuncture, the giving of a subcutaneous injection or infusion, acupuncture, or ear syringing. As stated earlier, one of the primary issues for the coroner investigating deaths occurring in healthcare settings is to determine the cause and manner of death. Cause and manner of death are two distinct matters and concepts. The autopsy report, or post-mortem as it is also known, essentially concludes what the cause of death was. This conclusion is based on physiology. However, the manner of death relates to the situation or context in which a death has occurred. As part of the process of the coronial investigation, the coroner is required to gather information. This usually begins with obtaining relevant records, most often including a copy of the clinical records. Requests for relevant documents and clinical records can be made informally. However, under Section 53, the coroner has power to give notice in writing to a person to produce documents or things, and most commonly this includes medical records, which may assist the coronial investigation. It is important to note that a coroner does not have power to issue a subpoena before an inquest is ordered. The other way in which the coroner investigates a reportable death is to request statements from relevant staff who are involved in the care and treatment of the deceased. Healthcare professionals often are requested to provide a statement detailing their involvement in caring for the deceased. Should you be asked to provide a statement, seek legal advice before providing a statement to the police. Do not be pressured to provide your statement then and there. You can seek the advice of your professional organisation or medical indemnity insurer. If panel solicitors, such as Hicksons lawyers, have been instructed to act for the local health district, they may be able to assist you in providing your statement. At the very least, you should seek advice from the relevant local health district contact person, who is usually attached to the risk management unit or clinical governance. The local health district can then provide you with direction and information on the process of providing a statement. They can also assist you with accessing a copy of the relevant clinical records and ensure you are appropriately supported if you are required to attend court to give evidence in relation to your statement. You may not know if you will be required to give evidence at a later time when you are initially asked to provide a statement, so it's important you seek the appropriate advice about the process and what is required of you to ensure your statement properly and accurately reflects your involvement with the deceased. The local health district is typically asked as an organisation to provide a statement to the coroner detailing any investigations undertaken into the death, whether any recommendations for change have been made, and if so, whether these have been implemented or not. The local health district statement in this regard is often a central consideration in the coroner deciding whether there is a need to hold an inquest. Once all relevant information is gathered for the coroner, it is compiled into the coronial brief of evidence and forms the complete set of documents that will be before the coroner to consider. The coroner's brief includes not only the statements from relevant persons and clinical records, but also the police investigation brief, which summarises the evidence, and other medical evidence, in particular the autopsy report. Independent expert reports may also be obtained on behalf of the coroner, which provide an opinion on cause or manner of death. Relevant policies and procedures may also form part of the brief. In the vast majority of cases investigated, the holding of an inquest is dispensed with because the answers to the questions are relatively clear and there are no general issues of public interest or safety to pursue. In deciding whether to hold an inquest, the coroner must bear in mind that in some circumstances, inquests are mandatory. Section 27 of the Act details those circumstances in which it is mandatory to hold an inquest. For example, if it appears to the coroner concerned that the person died or might have died as a result of a homicide, not including suicide. If it appears to the coroner concerned that it has not been sufficiently disclosed whether the person has died, or the person's identity and the date and place of the person's death have not been sufficiently disclosed, or if it appears to the coroner concerned that the manner and cause of the person's death have not been sufficiently disclosed. Aside from where an inquest is mandatory, a coroner has the power and discretion to dispense with an inquest pursuant to Section 25 of the Act. Comments have been made in the past by former Deputy State Coroner Dillon about the factors that influence the coroner's discretion in determining whether an inquest should be held. These factors include: are cause and manner of death established? Are the facts controversial? Are there care and treatment concerns? Are there public health or safety issues? Are there any other public interest issues? Are there professional conduct issues? Has the case been thoroughly investigated? Can or could recommendations be made? Before dispensing with an inquest, a coroner will liaise with the next of kin as to whether he or she wishes for an inquest to be conducted. If there is a decision that an inquest will not be held, it is a requirement that reasons are given in writing for this decision. Now we will move on to the actual inquest. Inquests are unlike criminal or civil proceedings, which are adversarial in nature. The proceedings are informal and unstructured. There are no pleadings, and it is not the forum in which monetary compensation is sought. There are no parties, only persons of interest and witnesses. The rules of evidence, including the Evidence Act of 1995, do not apply. However, there must be adherence to the exercise of procedural fairness. Aside from relatives who have a statutory right to appear at the inquest, all other persons must appear by leave only. If you are granted leave, then you are entitled to be legally represented. A person or entity who is considered to be of sufficient interest is generally one who may be the subject of negative comment by the coroner in his or her findings at the conclusion of the inquest. Prior to the inquest, the coroner will serve persons with letters of sufficient interest. If you receive such a letter, it is in your best interest to seek legal advice if you have not already done so prior, so you can be properly supported during the inquest. Unless you have a lawful excuse as a witness, you cannot refuse to give oral evidence if it is requested by the coroner. If you have been identified as a person of sufficient interest, you will be served with a subpoena to give evidence, which compels you to attend court to give evidence. Witnesses are entitled, however, to object to answering questions if a truthful answer may tend to incriminate them pursuant to Section 58. If a coroner, however, ultimately determines that he or she requires you to give evidence in the interests of justice, you can answer the questions asked of you under the protection of a certificate pursuant to Section 61. If you are required to give evidence, there are some matters which you should have regard for. For example, prepare yourself for court. Arrive early to meet with your legal team. Be mindful of your attire. Be comfortable, but ensure that you are dressed smartly. If you are uncomfortable, it will be obvious. Be aware that you will be asked to swear an oath or affirm to tell the truth. Familiarise yourself with the courtroom setup. Read over your statement beforehand. Read through and familiarise yourself with the clinical records. Know who will ask questions of you while you are in the witness box. Be mindful of how you answer questions. The most simplest yet hardest advice to follow in this regard is simply listen carefully and just answer the question, not the question you think is being asked of you. Raise any concerns or queries with your lawyer prior to giving evidence. It is important in terms of your practice to be aware that there are often common issues and criticisms which arise during the course of an inquest. These issues include the adequacy of documentation and record keeping. Often, these concerns relate to inadequate or incomplete documentation. Bear in mind that a medical record is considered a business record, and as such, it can be admitted as evidence in criminal proceedings, civil proceedings, and coronial inquiries. Records must be made contemporaneously or as soon as practical after a patient is seen. There must be sufficient information to identify the patient. The records must contain information known to you which is relevant to diagnosis and treatment, details of clinical opinion, details of the management and treatment plan, particulars of medication prescribed, and any information or advice given. A thorough, complete, and contemporaneous record can mean the difference between being criticised or not. In the words of Justice Hope in Albright versus Royal Prince Alfred Hospital, the records are likely to be a far more reliable source of truth than memory. They are often the only source of truth. Other issues which are often raised during inquests include communications between doctors and nurses, reluctance to contact the consultant on call, communications with family, the handover process, failure to recognise deterioration, failure to follow the between the flags, failure to act promptly, and knowledge of policy directives as well as local guidelines. Once all the oral evidence is heard, together with any independent expert evidence retained on behalf of the coroner, as well as the family statement, the coroner is required to make findings. In handing down findings pursuant to Section 81 of the Act, the coroner will be required to reach conclusions on the following issues: the person's identity, the date and place of the person's death, and in the case of an inquest that is being concluded, the cause and manner of the person's death. As mentioned earlier, the cause and manner of death is usually the primary focus for the coroner in inquests that relate to healthcare, as often the other matters are already known. The coroner can also make an open finding. An open finding is made where the evidence is insufficient to enable the coroner to make a finding, and usually this will relate to the manner and cause of death. For example, it may not be clear whether a person deliberately or accidentally overdoses on drugs. Findings are not always handed down at the conclusion of the inquest. Sometimes the coroner sets down a date in the near future to hand down his or her findings, following which the findings are then in the public arena and in general are made available on the Coroner's Court website. The coronial jurisdiction is one in which it is not appropriate to point the finger that a practitioner has acted negligently. It is not about naming and shaming. Having said that, as we referred to earlier on, the coroner can make adverse comments about one's acts or omissions. In doing so, the coroner can make recommendations at the conclusion of an inquest that an individual health practitioner be referred to their registering body for further investigation. Prior to making any such recommendations regarding individuals, organisations or agencies, including local health districts, parties represented are afforded the opportunity to make submissions in this regard, either orally or in writing to the coroner, as to the reasons why or why not recommendations should be made. As prescribed by Section 3 of the Act, the coroner has the power to make recommendations concerning public health and safety. This is with the aim of preventing deaths in similar situations in the future. Recommendations of this nature are often directed at agencies such as the Ministry of Health and local health districts. There is no legislative requirement per se compelling agencies to respond to recommendations. However, in the event the recommendations are directed to government agencies, they do require referral to the Attorney-General, with details noting the steps taken to address the coroner's recommendation.
That concludes this episode of Hicksons Health Hour. Thanks for listening. We hope you enjoyed this episode. Make sure you listen to the rest of the series. If you would like to find out more, please visit hicksons.com.au.